Hello and welcome. Today we are going to talk about abuse of dominant position regarding Google case, especially Google Shopping.
Think of Google Shopping as your little matchmaker. Say you sell a set of these, or some of those, or a pair of these. Someone out there is searching for what you're selling, and Google Shopping helps them find you. It gets your products on Google, other sites, and in front of mobile shoppers. Just upload your inventory in the Merchant Center, create a shopping campaign in AdWords, and there you go. Your products are online in a format that shows shoppers you've got exactly what they're looking for. And you only pay when someone clicks through to your site. So Google Shopping can help you get big results on a smaller budget. Reaching customers who love your products as much as you do is a win-win. And that's exactly what Google Shopping helps you do.
The European Commission has fined Google a record-breaking €2.4 billion fine for antitrust violation pertaining to its Google Shopping search comparison service. It is widely considered the most significant antitrust ruling in Europe since the 2004 Microsoft decision.
Today, the Commission has decided to fine Google €2.4 billion for breaching EU antitrust rules. Google has abused its market dominance as a search engine by giving illegal advantages to another Google product, its shopping comparison service. Google must end this conduct within 90 days or face penalty payments. Google has abused its market dominance in its search engine by promoting its own shopping comparison service in its search results and demoting its competitors. What Google has done is illegal under EU antitrust rules. It has denied other companies the chance to compete on the merits and to innovate. And most importantly, it has denied European consumers the benefits of competition, genuine choice and innovation.
Its findings state that, first, Google has systematically given prominent placement to its own comparison shopping service. When a consumer enters a query into the Google search engine in relation to which Google's comparison shopping service wants to show results, these are displayed at or near the top of the search results. Second, Google has demoted rival comparison shopping services in its search result. Rival comparison shopping services appear in Google's search results on the basis of Google's generic search algorithms. Google has included a number of criteria in these algorithms, as a result of which rival comparison shopping services are demoted. What was the reaction in Google's headquarters then?
No, God! No, God, please, no! 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 No!
On October 2013, European Commission Competition Commissioner Joaquín Almunia explained to the European Parliament what was the European Commission doing on allegations of abuse of Google's dominant position. In November 2010, the Commission initiated a proceeding which was still unfinished at the time. The European Commission has submitted its preliminary assessment to Google, but there were still no views on the solution proposed by competitors. Commissioner Almunia explained that Google first proposed its solution, then the proposal was market tested, and the Commission responded to Google by presenting its assessment in July 2013. its content was clear that the Commission was not satisfied with Google's solution.
Yeah.
Lieutenant Drebin, police squad.
Oh, I remember you, Drebin. What do you want?
I want to ask you some questions. You familiar with that face?
I don't know. My memory ain't so great.
Oh, yeah? Maybe this will refresh your memory.
I don't know. It's still kind of hazy.
How about this?
Yeah, I remember him. I used to see him around. Why do you want to know?
I can't tell you that.
Well, maybe this'll help.
I really don't think I should.
Yeah, you still don't think so?
All right, his name is Nordberg. He's a cop.
He was no cop. He was dealing H.
What?
I'm telling you, he was dirty.
Oh, you sniveling scum. I ought to run you in right now.
All right. He worked at Ludwig Shipping. He tried to push something on one of my boys. I swear it. So what are you going to do about it, copper?
Well, why should I tell you?
Maybe this'll help.
I still don't think I should tell you.
Can you spot me at 20? How about now?
All right, I'm going down to Ludwig's office.
These were again subjected to a market test, which resulted in a further Commission's position on the Google's proposal. February 2014, Joaquin Almunia at a press conference again explained things to do in the case against Google. At the time, he said, following 2 market consultations and a dialogue with Google, the company presented commitments that they were the basis for issuing decision under Article 9 of Regulation 1/2003. Article 102 TFU belongs to the Commons EU's competition rules addressed to companies. This provision prohibits, as a practice restricting competition, the abuse of a dominant position in the internal market or in a substantial part of it. The essence of this prohibition is eliminating the prevention, restriction, or distortion of competition in the market through unilateral, usually individual behavior of dominant undertakings. The Court of Justice presented a comprehensive definition of a dominant position in the case United Brands. According to the court, the dominant position is occupied by undertaking whose activity hampers the maintenance of effective competition on the relevant market, and at the same time, it can behave independently of its competitors, customers, and consumers.
I make my own money, so I spend it how I like. I'm just living life.
In the case Hoffman-LaRoche, the court clarified that definition by starting that a dominant position, unlike a monopoly, does not exclude a certain extent of competition, but allows the undertaking to at least materially affect the conditions in which competition can develop, and in any case behave without taking these conditions into account, without suffering any harm. It must be emphasized that the occupation by an undertaking of a dominant position is not prohibited in the light of Article 102 TFU. A leading market position may be the natural result of competitive competition between economic operators, according to the first take everything principle. The existence of a dominant undertaking on the market does not itself constitute a charge. Case Michelin 1. At the very least, provokes a state of suspicion, as undoubtedly competition on a given market under conditions of dominance of one or more entities is naturally weakened. The main complaint, and in any event mentioned first, which the Commission addressed to Google, considering that the conduct might infringe Article 102 TFU, for example, reduce the rankings of the results of a free search service provided by Google competitors, In example, services that allow users to find certain types of information, such as restaurants, hotels in a particular region, specific products. In other words, the subject of the allegation was Google's favor in the results, let's say general search, of their own specialized products, which also serve to search, although more detailed, such as Google Maps, Google Places, Google Shopping.
Interesting.
So, what was Google's reaction to that? What were their suggestions and arguments in this case? Answers to these questions will be revealed in the next episode. So, stay tuned and have a nice day.